Alrighty, thanks for joining today. We're going to go through the contract to buy and sell real estate residential. And since you're watching here, that means you're looking to purchase a house soon. So we're going through this contract here so that you're familiar with exactly what you're going to be submitting to a seller. This is the contract that we fill out. Both the buyers and the sellers need to sign it before going under contract, realtors included. So this will go out, be filled out based on exactly what you're looking to do, hopefully specified towards what the seller needs so that we can come to an agreement. This document is created by the attorneys of the state of Colorado and the Colorado Real Estate Commission. This is not something from myself or eXp Realty. And as you'll notice, it's 19 pages long. We're going to skip a lot of it in terms of how we go through it with our residential buyers. You'll notice just on the first couple of pages, for example, there are sections for leasing properties. You can buy farms with this contract. You can buy commercial and retail real estate, like a pizza shop with this document. So we're going to skip what does not apply. We'll cover the sections that do apply for most of our clients. That way, you can take this time to familiarize yourself with it, ask questions, but ultimately when we write the offer, send it over to review. It's not the first time that you're seeing it. So now that we've got the introduction portion out of the way, we're going to go from top to bottom, going through each page of this. So again, it's the contract to buy and sell real estate residential. This is updated as of 2023. And at the top, you'll notice that we'll have a date section here. That's going to be the date of when we write the contract. That'll be the date notated furthermore once we're under contract and get it accepted. Then we have the buyer. That's where all the buyer's legal names as they want it and title go. Joint tenants, tenants in common or other tenants in severalty based on how a buyer is purchasing. Either two equal buyers with equal and full ownership with survivorship rights, or tenants in common. Maybe you're investors or not yet married and you want to have equal or non-equal but separate saleable ownership, or tenants in severalty, buying yourself. Unless otherwise noted, this contract is not assignable. So if you're a wholesaler looking to assign this to an investor, you would have to write it in as such. The seller would be put into this section that's blue here based on public records and how it's held, whether it's an individual, a couple, a trust, or multiple owners. Then we're going to put in the county in which the property resides and the legal description that will take off county records. We'll have the property's known address, such as 123 Main Street, put into the street address form. Under the inclusions section, that's where we notate which items we want the seller to include with the sale of the property. So anything that is physically fixed or attached to the property is included with the sale unless otherwise noted. So that's going to be the entire list of properties, items that are noted here. And then things that we'll typically notate in the blank section below are things like the washer and the dryer, if those are included or you want them, the oven range, the microwave, things like that. Rose bushes, things like that are included unless otherwise noted. Some people have their prized rose bushes, but really we can include anything attached or detached that we want in this section. We'll try and keep personal property outside of the contract as it can have negative repercussions for taxes and for closing with bills of sales and all those things required. We can simplify it. Remote controls if there's a garage, solar panels, water softeners, security systems, satellite systems, any of those common items can be checked here. And then we'll go to the next couple of pages here. So we have encumbered inclusions. That would be something like a propane tank or solar panels that still have a lease on them or not yet paid off. Then we have parking and storage facilities. Let's say we're in a condo or townhouse complex that has an owned parking space or a owned garage stall, or it's something that can be leased or given temporary access to with an additional cost. We'll put those in there. Again, leased items are going to be things that are on the property that are not owned by the homeowner but will be transferring. Exclusions, typically it is seller's personal property written in there, and maybe like a clothes washer and clothes dryer that are not included because they're taking to their next property. Most properties besides acreage properties do not include water or mineral rights that are written in here. Those are often taken by the developer or kept by the homeowner or property owner that sold to the developer way back when. All right, we're going to get into the dates and deadlines section here. So we have a time of day deadline at the top. That is when each official date ends. So we can have that at 6, 7, 8 o'clock or midnight. We can keep it at, depending on when you want to end your day. I don't know about you, but I don't want to be negotiating contract terms at 10 or 11 o'clock when we should be enjoying our day or evening with family. Alternative earnest money deadline. This is required by the state, null and void if it's left blank. So we're going to have a typical 1% deposit required by the seller to go to the title company. We'll fill in the date there. It's typically 3 business days after we go under contract. For the title deadlines, 1, 2, and then up on the next page, 3, 4, and 5. Typically 7, 9, and 10 business days away from the contract's beginning, which is when the seller will accept the contract. If there's an HOA, we'll try and get those documents as soon as possible within the first week, and then you have a chance to read through them and make sure that they're suitable to you. Check in, again, dog breed restrictions, parking restrictions, fences, payments, increases, things like that. Seller property disclosure below that is going to be a disclosure in which the seller notates each and every item of the property that are actually known by them. Then we have a lead-based paint disclosure deadline required for all properties built before 1978. Just so you know, you do not have to get a specialist out there to check for lead-based paint. Something pretty easy you can do yourself, or just paint over old paint and keep it pretty safe for you and your family. But you do have the option to get someone out or have a deadline for that document. Loan and credit, these first 3 at the top are where we add in some protections in case you need to finish getting your loan application done, which is actually just built on a scenario rather than a specific property when you get going. That means you could choose to switch lenders and get a different loan, or just get a different loan throughout the process as long as you still close on time, or make any changes to it. Maybe interest rates change. If something changes and is unfavorable to you, we want time allowed in the contract for you to be able to terminate without financial repercussions. A lot of these will not apply to most of our clients, either getting a loan directly from the seller or private money, things like that. Appraisal are going to apply predominantly to conventional loans. FHA guidelines run a little bit differently to where there's no deadline required in there. But typically we're going to give about 2 weeks for the appraisal management group to get somebody out to appraise the property and get the report back to us. Our best chances, what we're hoping for, getting a thumbs up saying you're good to go, or it came in above value and you got some free equity baked into your purchase. If something goes wrong, we're going to give ourselves another day or 2 on each of these deadlines to allow for some negotiation, some thoughts to happen, so we can make the necessary changes and ideally get us moving forward to closing. Surveys are not required, but you can always get one if you want. With most neighborhoods, they are going to be pretty straightforward in where the lot lines sit. But if there's ever a question, or if it's an acreage property, you want to be sure, make sure we write enough time in that contract, as some of those surveyors can be booked about a month or more out. So just keep that in mind, but it's typically going to be dependent on property type. Inspection and due diligence, we're going to get that inspection done typically in the first 7 days of being under contract. We do have some great inspectors that we can recommend over to you. They're going to come out and suggest that you meet with them for the last hour or so to get a summary of what they found and just some information like the emergency water shutoff and power, so you can be safe in your new property. So we're going to have the objection and the termination on the same day, between 7 and 10 days out from the start of the contract, more than likely. And then we're going to have the resolution 2 to 3 days following that to have some time for the seller to respond and come to an agreement with you. Below that is the property insurance termination deadline. We can recommend over to you some great home insurance companies. It's typically cheaper to put your car insurance in there and create packages so that you can get lower prices, but just make sure you shop around, ask the right questions, and find someone that you trust. Due diligence, we're going to have those due typically within the first week. We're going to ask the sellers to get all documents pertaining to transferable warranties like roofs and appliance warranties. We're going to have them get together any invoices from any work completed that was expensive, let's say over $1,000 in the last 18 months, things like that. Then conditional sale deadline, if you have a house to sell and your purchase is contingent on selling that house so you can get the funds, then we will put in a date in there that you have to sell your house by. Otherwise, you need to negotiate more time or terminate the contract. We'll get closing date, again, typically 30 to 45 days out from the date of acceptance. Possession can either be the seller staying and will delay possession, or changing ownership and changing hands as soon as the closing happens, so at the closing table. So for example, January 1st, possession date, January 1st, possession time, delivery of deed. That means you're getting ownership and possession at the same time. Then acceptance deadline, date and time. That is where we give the sellers a specific amount of time to accept, reject, or counteroffer this contract. So moving forward, we're going to have the computation period of days deadline right up at the top. And that says if any of the dates and deadlines fall on a weekend or state or federal holiday where the title company is closed, we'll just move that date automatically to the next business day. So we'll have will checked in there. We'll have the purchase price put into this section here. We'll make sure it matches at the bottom by having the correct amount of cash at closing, which you'll have talked to your lender about if you're using a loan. We'll have your loan balance here and then the earnest money at the top. So we're going to make sure all that lines up. If the seller is paying you any credits to cover loan costs or a rate buy down, then we will put those costs in this blue box here at 4.2. And then your earnest money will be delivered in the form of a check or a wire transfer, which we'll write as good funds and held by the title company's name that is set forth in the MLS. So we'll have all that information. All right, moving to the next page, we're going to have some loan information here. So that's what type of loan you're using, conventional, FHA, VA, etc. And we're going to skip this section below because that's if you're assuming the seller's loan. There's private financing terms. There's termination financing terms. Obligation. So a lot of this, you'll notice there's no fill in the blanks on the left side here, except for when we get to the next page talking about the appraisal. You'll notice if there's an FHA loan happening, you actually do not have to buy the house if it does not appraise to the purchase price, same as a VA loan. And the cost of the appraisal, this is where we choose it right here. So whether you're paying it or the seller's paying it, but it is traditional that the buyer pays. Owners Association information here, and that's just that time period. We're just going to get those documents from the seller and make sure everything lines up with what you want, what you need, like we've been over a few times, dog breed restrictions, parking, fences, cost adjustments, you name it. Take a deep look in there. That's part of the buyer due diligence. So you'll have some time to do that. It'll be written in the contract in the dates and deadlines section. Number 8, this is where we start the buyer, seller, or split buyer and seller checkboxes of who's paying for things. Typically, the seller is going to select the title insurance policy, which allows them to select the title company, and that's a $1,500 to $2,000 fee roughly for the sellers. You can feel free to take that on if you want to be a much more competitive buyer, and then we will choose our own title company. You'll pay that expense. Owner's extended coverage below that, 8.1.3, is going to be where we check essentially an additional title policy for unrecorded easements and surveys or mechanics liens, things like that could come up after closing. We just want that added protection. It's about $175, and you definitely want that. We typically split it in half unless we're being really competitive, and then the buyer will pay it. Any title documents are going to be responsibility of the title company. They're going to do their search. Let us know if they found anything. If not, that is a good thing. Section 8.5 on the right page, we're going to go over the tax cert. That's new for this year. That the tax cert will come in, it's $20 roughly, and we'll typically have the buyer pay that. It just comes in an email. Most people don't open it, but it's a good thing to do so. Then we go through, and we'll go into some of these items here. You'll see oil and gas stuff. Again, most of that's not applicable. Then surveys, again, most of the time that's inapplicable unless you're buying an acreage piece of land or opt to get a survey or ILC done. Seller's property disclosure will come in through most transactions. If the seller hides something, that's a real bad thing in Colorado. The sellers are required to disclose all known facts. And if there's something that was broken or damaged that you're required to fix, it's pretty simply attained in a small claims court or mediation period. All buyers have the right to an inspection in Colorado, one or more, for the physical condition or specifics like electrical, plumbing, or structural surveys. The seller needs to provide access to that, and if they don't, then you have the right to terminate the contract. Once we ask for certain inspection items to be fixed, however, we do require that the seller has ample time within the dates of the contract to respond. And then the buyer can make their choice based on the response, but they cannot get the cold feet in between objecting and waiting for the response. Otherwise, the seller has the right to keep the earnest money and terminate the transaction. So just keep in mind, once we start that period, we're going to give them some time to respond and say what they're willing to replace, repair, or give you money for, and then you can make your decision whether that's suitable or not. You do have a chance to make sure the property is insurable. So if it's in a fire or floodplain, that's going to make it much more expensive. That's your call whether you move forward or not. Excuse me. If the property is a rental property, then we can request all the occupancy agreements and leases. Due diligence sections, again, where we're going to request any documents that you're curious about. 10.7 is a conditional sale of the property. If you're needing to sell a property first, we just put the address in there. Below that, 10.8, we either say you do or do not have received the seller property disclosure. I'll know that immediately after looking at the property online. It'll either be an attachment or not, and then we'll note whether there's a well or there is no well on the property. If the property is older than 1978, then there was a requirement to have a lead-based paint disclosure accompanying the contract at time of offering. So make sure that's in there, and then all properties are required to have a carbon monoxide alarm. Sellers are required to disclose if there's ever been meth smoked in or cooked in the property. And then closing documents, section 12. The title company will get us all settlement statements, typically about a week, but usually 2 to 3 days in advance of closing. We'll go through them, make sure they look good. Sometimes they need to be fixed at the closing table, and it just takes a minute. That's all right. Closing instructions are either attached or not, same place as the seller property disclosure would be, so we'll know that real quick, and we'll check that box for you. Closing, designated by, typically mutual agreement. We'll choose together when and where to meet, sometimes together, sometimes separate, sometimes out of state. And all those documents will be signed, returned, and we'll schedule it with the transfer of funds. Transfer of title is generally a general warranty deed unless there's an outlying circumstance that the title company or the seller has told us about in advance. All the liens and encumbrances will be paid off. That's part of a clear title transfer within a real estate sale. So the title company is facilitating. Section 15, closing costs. This is where we start the next section of buyer, seller, or split expenses. So the closing costs, closing services fee, for example, is about $375, the title companies that we recommend. And we typically have that split, 1/2 buyer and 1/2 seller. Then we have the status letter fee, and some of these other fees are all HOA related. If there's an HOA, we'll choose as part of our negotiation, either buyer, seller, or split in the middle. Some of them can be $100 or $50, $200. Some of them can be quite a bit more in some of the nicer condo buildings in downtown Denver, for example. One city that we've worked with has a transfer tax or water transfer fee, but typically those are just left blank. FIRPTA we fill in if our buyer clients are not of U.S. citizenship, as there is different tax servicing rules that apply and you need to be understanding of. Number 16, prorations are going to be based on the most recent mill levy. So when was the last time the property was assessed? The taxes will be based on that and prorated based on that. So the seller will actually pay the buyer the amount of taxes from January 1 until the day that they close in the house that year, because the buyer will be responsible for paying those taxes when tax time comes. All right, if there's rents involved, we talk about it here. And then if there's any HOA assessments that have yet to be paid upon closing, who pays them, buyer or seller? Bottom of the left page here, that's where we choose. Possession, at the top right, section 17, if the seller does not vacate the property for the buyer to have possession at the correct date and time, we will fill in somewhere between $300 and $500 per day that they'll owe you for not vacating. That's, general hotel and inconvenience fees for you to have to take short-term housing. We hope that that doesn't happen, but this keeps an added layer of protection in there. All right. Seller's responsible for the condition of the property during the closing. They can get a home warranty, but their insurance is still covering it during that time. you want to make sure all of your insurance and such starts immediately, which will be part of the process we'll walk you through. Section 19, we can recommend an attorney or CPA if you need one, but that is not a service that we offer. It's not a license that we hold. So just let us know if you need one, but know that you are, by signing this contract, agreeing to mediation, which is the free version of needing an attorney. Should something come up, we can seek mediation first before seeking an attorney. Time is of the essence in all dates and deadlines. So that means if any of the dates and deadlines pass, the contract is effectively null and void. It is terminated. However, if both buyer and seller wish to continue a contract after a date and deadline is passed, and they both continue proceeding forward without terminating, then that contract without any additional paperwork can continue moving forwards. All right, we're going to skip down to section 21. Legal fees, costs, and expenses are owed by the party that loses. So the prevailing party is responsible for all reasonable costs and expenses, including attorney fees, legal fees, and expenses. Mediation just went through that. Again, if there's earnest money disputes, that would fall under mediation and legal expenses. And the rights of the parties to cancel at the bottom of the left page here are set forth in the dates, deadlines, and all the contract provisions that we've gone through here, or maybe even ones that we have not talked about yet, depending on what applies to you. Section 25, this is the whole contract, and there is no editing of it. Once it's fully signed, nobody can make changes without doing an amendment. Amendments are common. Sometimes there'll be a few changes throughout the process, but all parties will sign and agree to those. These contracts will be sent, typically digitally, through CTME or text message within some form of electronic delivery. All those signatures are logged and date and time stamped. We know where they came from. They're legal with the U.S. government, and they keep everyone protected. If we do need to make changes, again, they can be done, but with an amendment rather than just changing a contract. That would be illegal to do so otherwise. All right, this contract is done in good faith, Section 28. That means you intend to follow all of the things that we've checked and filled out here. You intend to buy the property. Let's say the price comes down with the appraisal or goes up. If you intended to buy it at $650,000, but you have to bring an extra $20,000 because the appraisal came in at $630,000, then you were intending to buy it with the littler amount of cash out of pocket, and you can choose to terminate versus bring the extra. Or the inspection, you were intending to buy it as is, but something came up that you were not okay with fixing, so you decided to terminate under the inspection provisions. You have quite a few reasons to exit, but the intention is to purchase and move forward and not just lock up contracts and lock up houses. For example, that would be if you submitted 3 contracts to 3 different sellers hoping that one of them stuck, then those would not be made in good faith because you were only intending to buy one of them. Additional provisions, we might put something in here, but typically it's going to be left blank. And then beyond this is where you would sign. You would have your name, your signature, your date, and we'll put in your general contact information for the title company to be able to reach you. And then our information is to fill out below that. So that is a purchase agreement here in the state of Colorado. Allows us to buy pretty much any type of real estate. And if you have any questions, bring them to our meeting. Shoot me an email or a text. But this is how we go through contracts with our clients. And just wanted you to have a sneak peek at it so that if there were any questions or maybe you just wanted to see it twice, that you could feel comfortable signing it and save some time if you found a property before having gone through this with us later, that you're able to pounce on it and know exactly what each and every checkbox means. Know that when we're going to send off an offer for you, I'll have a list of items that are checked that change things for you. So what things we're committing you to paying for versus them. So you'll have a summary of it in an email format, and you'll know, having seen this video, of what they're actually applying to. So again, if you have any questions, let me know. Otherwise, I'm glad that we could go through this and that you could see it in advance, either first and only or just a time in advance. So it's been about 25 minutes. So thanks again for watching. I know this took a lot of time, but this is everything you need to know to make a smart offer.